Hi folks, this is Louis Martin, here to talk about Unit 3 Criminal Law. So hopefully by now you might have the opportunity to have a read through that chapter and have a think about some introduction to criminal law. Obviously I know how busy you are, and trying to fit it in is difficult, but try to get an overview about what's on the chapter. Obviously at this stage you probably haven't got time to go into the minute detail. But what I'll do now is I'll just explain some of the fundamentals. You may want to have a look at this book. It's not required. This is the CILEx Criminal Law Course Manual. But all the information you need is on the internet or in the chapters that I'm going to put on. So you don't need to worry about actually having that book. It is very good, and it does summarise things quite nicely. And what I'll do then, I'll go through the first sort of general principles of criminal liability. So to establish criminal liability, the courts, so you've got the magistrates, the Crown Court, the Crown Prosecution Service, are going to look at the evidence presented by the police, make sure it's obviously been submitted according to the rules of evidence and rules, and they are then going to see if they've got the Actus reus plus the mens rea, and no plausible defences that are obvious, or strict liability. And that will establish criminal liability. So when we talk about criminal law, we're looking to establish criminal liability, blameworthiness, the blame, and then punish accordingly. So the Actus reus must coincide with the mens rea. So what that means is the Actus reus is everything contained within a criminal offence apart from the guilty mind. This. Simplistically, Actus reus is the guilty act, the physical element, the external element of the crime. The mens rea is the mental element, mente. The mental element, the mind, the fault element, as it's sometimes referred to. When both the guilty act and the guilty mind combine, then we've got the basis of some criminal liability. It is, on a simplistic level, I always use the criminal law liability equation, Actus reus plus mens rea, or strict liability, minus a defence equals criminal liability. And if you think about that, you will not go far wrong. When it comes to Actus reus is split into different components. Fundamentally, a person has to act voluntarily. So if somebody commits a crime, they have to do it of their own volition. So that's the first principle. Secondly, with different types of crimes, simplistically, we have a conduct crime, which is the person's actual conduct is sufficient for the cause of the crime, such as a fraud. The commission of the fraud itself, whether the fraud's successful or not, is immaterial. Their behaviour is the crime. Driving with excess alcohol, it's the behaviour that's criminal. Growing a controlled drug, it's the growing process. So some crimes are committed merely by the actions, the physical action, the physical activity, and they're called conduct crimes. We also have circumstances. So a state of affairs. So if a person is drunk and incapable of standing up, then that person, by their mere state of affairs, could be guilty. So a couple of cases, you've got Windsor versus a Chief Constable of Kent, 1985, where he was drunk in a public highway, and that was sufficient. So they're called circumstances, a set of circumstances prevail. We also have the more complex form of Actus reus, which is the conduct crime which then results in a consequence, which is a result, a desired result or outcome. And we see this with a murder or a Section 18 wounding, where there has to be an end result. And that's the most important thing. And these are normally seen in the more complicated crimes. With this then, the prosecution have to prove beyond all reasonable doubt that the defendant was the factual and legal cause of that outcome. So one of the key elements in Actus reus is what we call causation. And that's where the prosecution have to prove that the defendant was the cause. And we see this with what's called the but-for test, R.V. White, 1910, where White gives his mother some lemonade which contains poison. And the mother drinks the lemonade but dies before the poison can take effect in her body. So he was not the factual cause of the death. He was charged and convicted of other offences, but he wasn't the factual cause. The Latin for this is sine qua non, without which not. Modern versions modern books call it the but-for test. But for the actions of the defendant would these consequences have occurred. So once the prosecution have established the factual cause, then they move on to establish whether the defendant was the legal cause, legal causation. And they need to establish whether the defendant was the substantial and operative cause of that result. And also, the defendant doesn't have to be the sole cause, but really they're looking for the defendant to be the most blameworthy. So there's a number of cases that have been developed to establish this. Some of the more famous cases are the medical cases, where defendants have shot or stabbed victims and then doctors have intervened and doctors have treated people and people have gone to subsequently die. And the defendants have argued that it was actually the doctors that caused the death and not them. And the courts established this notion of their conduct is the operative and substantial cause of the death, of the consequence, of the result. So when you do your reading, have a look at the medical cases. You've got Smith, Cheshire, and Jordan. And then we've also got the escape cases. This is where people have, the victims have done things which the defendants have then gone on to say has broken this chain of causation, as they themselves have almost brought it on themselves. And what we need to establish is the prosecution need to establish like this chain of causation, that the defendant was the operative and substantial cause and the most blameworthy of the result. So, for an example, in R.V. Smith, 1971, Smith offers a female a lift to a party, and en route in the car, he starts to grope the victim, and she believes that she may be sexually assaulted, so she jumps from the car, which is not exactly going fast, but she jumps from that and breaks her ankle. He's charged with an assault, and his defence is, well, I didn't actually cause this broken ankle. She's caused it herself. And the courts decided that the chain of causation hadn't been broken by her jumping from the car, that he was the most blameworthy cause, and he was the sort of substantial operative cause of that result. And we talk about breaking the chain of causation, they call it in Latin novus actus interveniens, and that's where the person or something happens which breaks this chain and breaks the sort of requirement for the prosecution to demonstrate that this person has caused the result. We also talk about omissions in Actus reus. So an omission is where somebody does not do something. So in English law, a person should not really be held liable for not doing something, for just standing back and not getting involved. There are some exceptions to this, and these are discussed under the Actus reus sort of umbrella, and these revolve around special duties of care. So, for example, the duty of a parent to care and look after a child. People who are paid have got contractual duties to employers and to protect the public, such as the police or, in the past, railway workers. Also, people who voluntarily take on a duty of care, such as a relative or a friend who is looking after a vulnerable person. So we see, as you'll see in the books, there are a number of cases where people have breached this duty of care, such as in the case of R.V. Adamaco, 1994. Adamaco is an anaesthetist who fails to properly supervise the administering of air and oxygen to a patient who dies, and Adamaco is subsequently convicted of gross negligence manslaughter. So he had the duty of care to the patient. The duty of care was breached. He didn't pay attention, or he momentarily lost concentration. The tube fell out of the mouth of the patient, and he was sort of held liable because the breach of the care was considered so gross, so serious, that it moved from civil law into criminal law, and he was convicted of manslaughter. So these are these special duties. I'll speak about mens rea in another video, but when you are going to have the exam, I've looked in the past papers, and there are regularly questions asking you to list the different types of Actus reus, or the themes that flow within Actus reus, and also some of the cases that I've mentioned. So I hope you'll find this interesting, and I'm going to provide another short YouTube clip about mens rea.